Hey there, in this video I'm going to be giving you a roadmap of how to get a domestic violence or domestic violence related case dismissed even after it has been filed in court. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video I'm going to be giving you a roadmap from a victory that I actually had this week in court of how to get your case dismissed even once it's been filed. And there are 9 different steps that I'm going to be going through when I explain this roadmap of how to get a case dismissed when it has been filed. Okay, so let's jump right in. Number 1, prepare a mitigation packet or a character packet. So basically what this mitigation packet, what this character packet is a letter from me explaining all of the good things about you, just a summary of them. And I have a whole process that I have my clients follow so that I can collect all of that and make sure that I have all of those details from you. It will also include character letters if you've done any classes, counseling, anything like that. If you have proof of any good things about you. So I've even had clients that submit photos of themselves with their children, with themselves volunteering in the community, coaching Little League. That can all be very, very helpful in the mitigation packet. So we want to have the mitigation packet together, basically explaining that you're a good person, your aspirations for the future, that you are a normal non-criminal. That is the goal of this packet, that when the DA looks at it and the DA, through their DA eyes, their DA lens, is thinking that everybody who has a case filed against them is a criminal, or at least that most of them are. They look at this and they're like, wait a second, this guy is normal. That's the goal. That's the mitigation packet. So I want the DA to have that in their file, and I want it to be a really strong packet, not something that's just a letter from me with nothing from you. We need to have the strongest packet that we possibly can. And so my team and I spend a lot of time, and in this particular case, spent a lot of time making sure that we had a strong mitigation packet. Number 2, once I get to court, then I start explaining the case to the DA. I start explaining the weaknesses of the case. I start showing them any evidence that I have or anything in the police report that just doesn't really make sense. The DA, believe it or not, is not necessarily the enemy in every one of these cases. Sometimes they become the enemy later on down the road, but many times, especially in these early stages when it's a relatively either low-level felony or a misdemeanor, the DA has so many of the cases and they don't know much about the case. So if I can make it easy to them and I can point out to them, hey, maybe they haven't even read the police report, right? Hey, in the police report it says this. This is kind of weird because there's this inconsistency over here. Or you can see that I have text messages, etc. over here that make it sort of inconsistent, and start showing them, hey, this case that you've been handed through no fault of your own, this case that you've been handed maybe isn't very strong and maybe isn't worthy of the resources of your office, your great office, in prosecuting it, right? Number 3, have the client always show up looking great. Okay, so this particular client, I didn't even have to tell him. He showed up always looking incredibly presentable and better than any other defendant in the room by far. Like, he respected the process. Like, he cared about what happened to his life. And if you were watching this and this is your first time that you were ever arrested, you might think, well, of course. Right, exactly. So you want to distinguish yourself from all the people that show up wearing torn t-shirts, dirty clothing, people who are trying to look cool instead of looking presentable and respectful. Number 4, whenever I talk to the DA, I need to remind him about all the good things about my client and why my client cannot possibly take a conviction. A great thing to include, if it's true, is my client wants to join the Army. My client wants to be a cop, because the DA, they've taken their job for a reason. They are law-abiding citizens. They are not rebels, right? And if they see, oh, this is a fellow law-abiding citizen, this is somebody like me, then that can help a lot. And the reason why I say remind, by the way, is that this process is often not fast. There may be multiple court dates. There might be 30 to 45 days between them. And I'll get into that in a little bit, but I need to make sure that when the DA has 25 to 45, maybe even more cases in one morning, and that's every single day, and they've had that happen for 30 days since they last saw me, I need to make sure that I remind them of the case, that I give them a little summary, that I make their job easy for them. Basically, also what I'm trying to do is I'm trying to move the DA onto my side as much as I can with every court date. And I know that some people think, and maybe based on what you see on TV when you watch criminal cases, you might think my attorney should be fighting with the DA the whole time. We do fight with the DA, and we should fight with the DA in some cases, but not early on. If the DA tells me to go kick rocks and that my client, who has been falsely accused, has never been arrested, has these big aspirations for the future, and the DA's case is not that strong, if the DA is going to tell me to kick rocks and that my client's going to jail, okay, then it's on. Then it's time for trial, and then I'm not trying to persuade them anymore or bring them onto my side. Instead, what I'm trying to do is demolish them. But it's not time yet, right? When you're trying to get one of these dismissed before trial, do everything that you can, play nice, point out problems with the case, be firm, stay steady on your client's side, and always make sure that it's clear to the DA that you genuinely like your client. Number 5, now that I have the DA sort of on my side, he's not against me anymore, really. He's maybe not offering to dismiss, but he probably doesn't have the power to dismiss. Number 5 is going to be that I meet with the DA's supervisor. So how this works is that I talk to the DA's supervisor on the phone. We set this up in advance, and I've already sent them the good things about my client. I've sent them my little pitch, and on the phone, I get to explain to them what I want to have happen with the case. And while I am going for a dismissal, especially in these cases where I think it's weak and I think that my client deserves for the case to be dismissed, typically I will talk to my client first and I will ask the client to at least agree to do classes of some kind, maybe a few online therapy sessions in exchange for a dismissal. That is something that could help a lot. To basically give me some ammunition so that I'm not just going in and saying we demand a dismissal to the DA supervisor, because that doesn't necessarily work. Instead, I'm saying, look, I think that this case should be dismissed, but my client, and again, I'm showing the DA supervisor that my client is a reasonable person. My client is willing to, just to reassure you guys a little bit, to make you happy, is willing to do some of these online classes or whatever the client has agreed to. I presented my client as a reasonable person, because any attorneys in this system, me included, DA supervisor included, if you know what's going on and you know how the system works and you are reasonable, you would always take classes in exchange for a dismissal. So the fact that I'm saying, hey, my client is like us, like you, one of us, and would take these classes if it meant that he could just move on with his life and become a cop and work with you and live happily ever after, that's more points in my client's favor, and it definitely was in this case. And in this particular case, the DA supervisor actually agreed to look at the case and see if there was even a strong enough case to proceed to trial, which was awesome. He's saying that he's considering potentially not even having my client do those classes. Number 6, be flexible. Agree to keep coming to court, make it convenient for the DA, for the DA supervisor. It's not fun for my client if they have to show up. They don't always have to show up, but if they have to, it's not fun. And of course, they want the whole thing behind them. But the most effective thing for me to do, the most effective thing for your attorney to do, is going to be flexible with them. To say, okay, I understand you're going on vacation next week, or the DA supervisor has been super busy. No problem, I'll come back. It's worth it. It's worth it, because if you can possibly get the case dismissed before trial, it is even better than going to trial, and you want to do everything that you can to facilitate that. So make sure that your attorney is on the same page, because yeah, it's not necessarily fun, but it's our job, right? If you hired us to get you the best possible result in the case, then we need to do anything that we can to get you there. Number 7, set the case for trial. Okay, I just said be flexible, and now I'm telling you set the case for trial. How you want to do this is sort of try to manipulate the situation to get the judge to set the case for trial. Especially if the case is getting old, the judge does want to set the case for trial. And obviously, as I've been saying, as the defendant, you want to try to avoid trial. But the thing is that sometimes what you want to do to get the DA and the DA supervisor to have them really start to evaluate the case, have them start to talk to the witness. If it's your ex and your ex is lying, have them talk to your ex. Have them ask your ex the hard questions. The DA has probably video of your ex saying whatever negative things that they said about you to get the police to make the arrest in the first place. And your ex doesn't have that. And when you're lying, it's very hard to keep track of your lies. So let them start prepping for trial. Let them start to evaluate, hey, do I want to spend, 2 weeks of DA office resources, one entire DA getting paid their salary for 2 entire weeks or longer on this case? Is it really worth it to us? So the defense attorney can kind of go along with the judge here, and you have to feel the situation out. But in this particular case, the judge had set the case for trial, and that is what got the DA's office to get serious, really look at this case and figure out, is this something that we actually want to try? Number 8, be patient both with coming to court and while at court. So for this case, on multiple occasions, I sat there for hours waiting for the DA, waiting for the DA's supervisor. I could have left, I could have just continued the case, but I wanted to get an answer, and I wanted to show them that, hey, I really care about this case, and I'm patient, and my client is patient. We both have other places we could be, but we will sit here and we will wait for you. Number 9, win, prevail. So in this particular case, one day I showed up for court. The DA pulled me over aside to him and told me that finally he and the DA supervisor had agreed that they were going to dismiss the case. Anyway, I hope that you found this video helpful. If you do have a BS case that has been filed against you, this is a general roadmap that you need to take if you want to get it dismissed without going to trial. If you did find this video helpful, please don't forget to like, subscribe, ring the bell, and if you do have a case that you need help with in California, feel free to give me a call. You can find my number down below. You can also book a consultation there.